Welcome to this latest edition in our video interview series here at iConnect. My name is Richard Albert, and today we have a very special treat for our viewers. We have the very first edition in our new video interview series that will feature a book review, an online virtual book review where the author will meet critics. And today, the first book that we'll review is Tarun Khaitan's book on a theory of discrimination law, published just last year by Oxford University Press. And we'll be joined by Debbie Hellman of the University of Virginia and Julie Suk of Cardozo School of Law, currently visiting at Columbia Law School. Let me just tell you a little bit about Tarun's book from the perspective of Leslie Green, one of Tarun's colleagues at the University of Oxford. Leslie writes, "A theory of discrimination law is an engaging and engaged work on an important area of law by one of the most interesting new voices in legal theory." Now, I giggled a bit when I read Leslie's comments on the book, Tarun, because I've known you for many years, since our days at Oxford, and so to call you a new voice, I take the point. But for me, you're an old, wise voice from my perspective, and so it's a pleasure to have you here along with Debbie and Julie. And our plan for the next 25 to 30 minutes is to have Debbie kick us off with a few reflections on your book, Tarun, followed by Julie's own reflections. And then, Tarun, you'll have an opportunity to give your own reflections on the reflections on your book, and then we'll have an open conversation about what is an important book that we're very happy to be gathered here today to be discussing. So thank you all. And Debbie, let's hear from you.
Great. Well, first I'd like to say what an incredible pleasure it is to participate in this online discussion of Tarun's excellent book, and I can just hold it up so people can see. It's an impressive account of what discrimination law is and its moral justification. And I also want to thank you, Richard, for organizing this, and thank Tarun for writing such an excellent book that I learned so much from. I thought since I'm starting, I should say a little bit about the basic claims of the book for our listeners. So Tarun argues that discrimination is wrong because it exacerbates substantial, pervasive, and abiding relative group disadvantage, and because it makes a victim suffer because of normatively irrelevant or valuable group memberships. Now, relative group disadvantage is important. That's the kind of heart of the idea that discrimination is wrong because it exacerbates relative group disadvantage. And relative group disadvantage is important in Tarun's view because it, basically to cut to the chase, because it compromises freedom. Freedom is what grounds his view, and the basic idea is that in order to be free, people have to have access to 4 basic goods. That is, first, kind of basic biological needs, have their basic biological needs met. Secondly, they have to have negative freedom. Third, an adequate range of valuable options. And fourth, an adequate amount of self-respect. And the basic idea is that pervasive relative group disadvantage compromises a person's access to those basic goods and thereby compromises her or his ability to be free. Because the state has some obligation to secure our freedom and our access to those goods, discrimination law is thereby justified, because discrimination law is trying to minimize or diminish the relative group disadvantage and thereby protect our freedom. Now, Tarun recognizes that this account of discrimination law is somewhat at odds with a kind of lay understanding about what discrimination law is for, and to the extent that it is at odds with a lay understanding, he thinks it's the lay understanding that has to give, and that the lay understanding should follow the law's lead, as he says. So about this account, I'm going to raise 4 questions. I have a 5th one in reserve if we have time for it, but I'll start with 4. The first one is about the focus on relative group disadvantage. That is, I understand that in order to be free, we have to have access to these goods, and I understand how domination that comes from relative disadvantage can compromise our access to those goods, but I wasn't sure what was special about relative group disadvantage as opposed to just relative disadvantage in compromising our access to those basic goods. The case seems strongest to me with regard to self-respect, that relative group disadvantage could compromise our ability to have self-respect. That seemed a more intuitive connection to me, but I had a harder time with the other goods and their connection to relative group disadvantage. Second, Tarun argues that in order for the state to be justified in imposing a non-discrimination duty on actors, the act that the state would forbid would have to both exacerbate this relative group disadvantage and also make a person suffer because of a irrelevant or valuable trait. And both of those were necessary components before the state could impose a duty. But the account would suggest, if we put aside when the state imposes a duty, that just an ordinary person would have a reason to avoid acts that exacerbate relative group disadvantage, even when they aren't instances in which a person's suffering because of her membership in one of these groups. So Tarun discusses the example of a person who opens a shop opposite, let's say, a woman, and thereby harms the woman's business prospects because this is a competing shop, and you say that's not a case where a person has a legal duty not to open the competing store because the woman who's the shop owner doesn't suffer because of her membership in a group there. But that act certainly does exacerbate relative group disadvantage if your opening the shop causes her business prospects to suffer. So is this a reason why, say, a man should think about not opening a shop opposite a woman? That those concerns could give a person a reason not to exacerbate group disadvantage, and I wondered what you thought about that. Third, your account seems to go to great lengths in emphasizing that indirect discrimination is really it's of the same importance and really of a similar kind or type as direct discrimination, trying to minimize the difference between the two, rather than what some might think of as a standard account that direct discrimination is the paradigmatic case and indirect discrimination a kind of step cousin or something. But I wondered if your account actually makes indirect discrimination the paradigm case, in that that's the one where we're really looking at exacerbating relative group disadvantage. And the last question I wanted to ask is really not about the normative grounding of your account, but about how you characterize it. At one point you say that there's growing philosophical consensus or opinion that freedom rather than equality provides a better foundation for discrimination law. This is at page 113. And I wondered about that as a descriptive claim about what other scholars think, or whether that's just I'm tempted to say the proximity to Joseph Raz and the Oxford set, who think something along those lines. So I'll stop there.
Thank you, Debbie. We'll hear now from Julie.
Okay, great. So I too very much enjoyed reading Tarun's wide-ranging book, and I wanted to pick up by thinking about what a theory of discrimination law offers to the study of discrimination law, both as a national project and as a comparative project, and then pick up on some of the questions regarding what Tarun identifies as the essential or core features of discrimination law, which I think are perhaps more contested and less fixed than he takes them to be. And so we could start with the first question, which is about why have a theory of discrimination law? What I take Tarun to be doing in the book is to give a descriptive account of discrimination law as he finds it in what he describes as multiple leading jurisdictions, including the United States, the UK, Canada, and much of the common law world. And he gives a descriptive account of discrimination law as it's practiced and tries to identify the normative theories underlying those practices as they're expressed in doctrinal rules. And then it does seem that having described these normative theories or principles underlying discrimination law, he then tries to provide an account of the normative principles that might perhaps improve existing anti-discrimination law. And in so doing, it seems that what he adds to other existing scholarly approaches to discrimination law is an attempt to understand the normative commitments of those who are invoking and enforcing and building upon anti-discrimination legal norms. And he's doing so without regard for the political plausibility of pursuing these normative commitments to their logical or ideal conclusions. And I think that's why there is this emphasis on theory and doctrine. And so what I like about the account is that it doesn't try to reduce the practice of discrimination law to its politics, or even to just the limits of what's possible. But here I think the relationship between the description and the normative theory gets a little bit murky, because it does seem like, on the one hand, Tarun, is there a bit of an echo?
No, it's fine, Julie, from our perspective. Please continue.
Okay, because I'm getting the echo. But it does seem that what he identifies as the core features of anti-discrimination law include the duty to refrain from direct discrimination, the duty to refrain from indirect discrimination, the duty to refrain from harassment, duties to provide reasonable accommodation, and duties or licenses to undertake positive action. And I think each of these things have been, over time, contested at the moment that they're incorporated as a feature of discrimination law. And we could even think about the prohibition of direct discrimination, which I think bears a close relationship with a core feature that Tarun identifies, that discrimination law is primarily concerned with grounds, what he calls ground sensitivity. That any theory, he says on page 88, for example, any theory of discrimination law must account for this ground sensitivity generally and explain the basis on which the protected grounds are selected. And of course, he then goes on to link that to group disadvantage. And I do think also, though, that the concern with ground sensitivity is something that was incorporated into U.S. law as a way of understanding equal protection, which doesn't mention grounds, but it was understood in the early cases, like the slaughterhouse cases, that, of course, equal protection had to be understood through the grounds of race, and then other grounds like sex, disability, pregnancy, others that Tarun treats in the book eventually got added. But at least for a moment, it was possible to try to think about the idea of equality, or even the idea of non-discrimination, as being constructed closely related to the idea of equality itself, rather than through the idea of group disadvantage or group grounds. And I think there are other jurisdictions in which the idea of non-discrimination extends beyond group disadvantage to other forms of. So if you just think about appearance discrimination, which is going to be one of the main, which is going to be the subject of the employment discrimination session on discrimination law at the AALS meeting this coming Thursday or Friday, that it's possible to think about discrimination law as not incorporating this ground sensitivity. And we could tell a similar story about the other core feature. So indirect discrimination, this picks up on Debbie's question as well. The idea that indirect discrimination is possibly a paradigmatic feature of discrimination law, where in recent doctrine, though, it seems like indirect discrimination in U.S. constitutional law has never really been accepted as a theory of equal protection violation, but in more recent law, it's understood that because of its conflict with the prohibition on direct discrimination, it may not even be something that can be sustained at all, even if it's not a necessary feature of discrimination law. We could tell a similar story about the prohibition of harassment. That is, sexual harassment in particular is a social practice that appears to historically to have undermined women's equality in the workplace. But harassment itself is something I think that's highly contested, that we could think of it as a form of direct discrimination because it's differential treatment of two sexes, or we could relate it to things that have nothing to do with the historical practice that subordinated women in the workplace, but as a breach of a general duty of civility. In some ways, discrimination law as it practiced seems to go into that territory sometimes as well, because there are forms of harassment that tend to get reached. If you think about same-sex harassment and the way it's treated in current doctrine, those forms of harassment may have little to do with group disadvantage, but they're recognized by the law as well. And I don't want to go on too long with these examples, although finally I think affirmative action is also a very interesting one, that somehow Tarun seems to think that the authorization of affirmative action and possibly the duty to adopt affirmative action measures is a core feature of discrimination law, when in fact current doctrine seems to be moving towards a prohibition of affirmative action as a feature of discrimination law. And so we might invite this question: if there existed a body of law that we call discrimination law that actually outright banned affirmative action by neither requiring it nor allowing it, would we say that this was no longer something we could call discrimination law? And so when we think about all of these questions, I guess the big question with regard to the project is whether or not the practices of discrimination law are really holding together the normative theory, or whether the normative theory, the kind of freedom-oriented, perfectionist, liberal account of discrimination law, is our starting point rather than the practices themselves. And I guess I want to raise that question because I want to kind of push on why we think of freedom as opposed to equality as being this central to our understanding of what the purpose of discrimination law is. And here's where I guess I want to ask Tarun to elaborate further, that it seems like he rejects the account of discrimination law as being somehow interchangeable with or even closely normatively connected to equality. That is, and I think there are examples in other jurisdictions that might really challenge that view. And I'll just give one, which is the Equality Clause, and particularly constitutional sex discrimination law, as it's practiced through the Equality Clause of the German Basic Law. So Article 3 includes the non-discrimination. Article 3, Section 3 of the Basic Law in Germany includes a non-discrimination guarantee. So no person shall be favored or disfavored because of sex, parentage, race, language, all those grounds. And then Article 3.2, men and women shall have equal rights. The state shall promote the actual implementation of equal rights for women and men and take steps to eliminate disadvantages that now exist. And it seems like when it's formulated in that way, non-discrimination and equality, even if they're not treated as interchangeable, are treated as a relationship by which equality is seen as the purpose of the non-discrimination guarantee. And I guess I wondered if there was any reason regarding the practice of anti-discrimination law to think of freedom as opposed to equality as the normative foundation for this body of law. And raising that question, it can take us in a number of directions in terms of how we might rethink what the core features of discrimination law are in light of all the contestations that I've mentioned.
Well, thank you, Julie. And Tarun now, please take some time to respond to these really probing, piercing, important reflections on your book.
Thank you. I should start by thanking you, Richard, and to ICON for organizing and hosting this panel discussion, and to Debbie and Julie for their very generous and thoughtful and challenging engagement with my book. So, so let me try to answer some of these questions. Let me start with Debbie's question. It might be easiest if I just go through them in the sequence that they were asked. So Debbie, thank you for that accurate summary of my book. I think you did a better job than I might have managed myself. So your first question was that why be concerned with relative group disadvantage? What is special about the groupness, as it were, of relative disadvantage? So so the response is two-pronged, as it were. The first response is that I don't necessarily deny or need to deny that individual relative disadvantage or dominance should not be or is not of law's concern or moral concern. Right? So it may be worthwhile for the law and morality to tackle individual relative disadvantage. All I'm saying, or the claim in the book, is that that's not what discrimination law, as we have it, is doing. So it's an account of discrimination law, and the aspect of disadvantage that discrimination law engages with is one that is relative and attaches itself to groups. So I don't need to deny the other possibility as well. That said, and these are sort of half-baked quick comments. I'm not, but anyway, I'll throw them out anyway. I do think that the group dimension does lend itself to making our access to basic goods particularly problematic. And that's based on certain assumptions about the nature of power and how power operates in society. So the connection between relative group disadvantage and the denial of access to basic goods in the book is made through the assumption that social power is self-aggrandizing, that if it exists, that it tries to grow, and that the more concentrated this power is, the more efficient it is at becoming even more powerful, and this is a zero-sum game, and it comes at the cost of other groups. So group disadvantage just makes its translation into dominance more efficient, and especially when these group membership coincides with social identities. So that connection, I think, exists not just in the context of self-respect, but also in access to a range of opportunities. If a particular group is dominant in access to certain opportunities like employment or housing, it's more likely that access will be, or efforts will be made to try to retain that access within the group. So that was that. I suspect that's a claim about the particular moral urgency or salience of group disadvantage, but that is not to deny the possible moral salience of individual relative disadvantage as well. Your second question, which is that, so you quite rightly say that my claim is that for the law to be able to intervene, the justificatory threshold requires both conditions to be satisfied, which is that relative group disadvantage is exacerbated and that the individual claimant suffers because of an irrelevant or valuable trait. And you ask me quite rightly, what about, am I acting wrongly if I open a store next to a businesswoman and outcompete her? And the point of the example was in the book to show that while this does, because it does not make her suffer because of her sex, the law should not step in. I'm going to bite the bullet on this. I think that it is of moral concern. It ought to be of moral concern to us when our actions have adverse consequences for members of disadvantaged groups. That is not to say that these actions are necessarily wrongful, all things considered, but it is a consideration that we ought to have even if the action is morally wrong, all things considered, we may still have a moral right to do it. We often have moral rights to do wrong things, like expressing hateful ideas, for example. So yes, I think there is a moral problem there, even if not a legal one, or at least a prima facie moral problem there. Your third question about the heart of moral justification for discrimination law, does my view give priority to indirect discrimination, or does it make that paradigm? I'm tempted to bite the bullet on this one as well. In fact, well, I have evolving practice, certainly in the UK on my side, but arguably Canada as well, where British law has begun casting direct discrimination in the light of an impact-based indirect discrimination understanding, and the Canadian efforts to get rid of the distinction, I think, are sort of motivated by similar considerations. The practical concern, obviously, is that there are far fewer cases of old-fashioned, intentional or motivated, malicious direct discrimination, where there is clear prejudice. So those types of cases are in at least certain types of Western societies fewer, and those that exist are harder to prove. And at least some jurisdictions are in fact moving towards a more consequences-based understanding of direct discrimination as well. I say I'm tempted to bite the bullet in this because I don't want to give up the traditional understanding of direct discrimination. I think all of that does neatly fit within an effect-based understanding of discrimination generally. So we don't have to take it out or expunge it from existing law. It's just that our understanding of discrimination as based on real life impact is indeed affecting our notions of direct discrimination. In fact, I think just thinking ahead, some of the growing literature on unconscious bias does appear to suggest that we ought to think about unintentional discrimination seriously. In fact, precisely because it's harder to put your finger on, and it's harder to acknowledge why this may be wrongful. It's the wrongfulness of disparate impact is not to many people as obvious as disparate treatment, and that may actually be a reason why it should have greater moral urgency if the background moral conditions, if my background moral story is the right one. Your final question. So to this I'm going to plead not guilty. So I went back to page 113, and I think I used the word opinion quite advisedly there. I do not intend to suggest that there is a growing philosophical consensus that freedom rather than equality provides a better foundation for discrimination law. That is plainly untrue, and this is, as it were, a non-relative claim that the philosophical opinion that freedom might underpin discrimination law is growing. It is more people claim that is the case than they used to, but not vis-a-vis those who think that equality underpins discrimination law. So let me move then to Julie's questions and comments. So Julie, again, thank you very much for your generous engagement with the ideas. I think the question you raise is one that I grappled with for quite some time. It's a deep methodological question. I think the question really relates to how does one theorize about any particular area of law, right? So rather than thinking generally about jurisprudence, the nature of law, the relationship between law and morality, etc., which obviously the last 50 years has seen a lot of scholarship on. I think when we start looking at areas like tort law or discrimination law or criminal law, one has to ask questions, including questions of identity. What makes these areas of law areas of law? Is it because the practice of law decides to carve out this area called criminal law? These areas are divided up on different bases, some based on the mode of implementation, maybe, or the sanction that the state visits, like criminal law, others based on a particular transaction at the heart of that area of law, like contract or maybe property. So those questions arise, and then there are the types of questions that you posed to me, and I don't think that those questions apply just to this book, but any inquiry of this nature, which is how do you deal with the practice of discrimination law or tort law, and how do you deal with the fact that practice in these areas of law is invariably going to be different across jurisdictions. Right? So the way I tried dealing with that problem was this. So the starting point is that any theoretical enterprise has to be a modest one. Theory cannot and should not hope to solve all practical questions, because theoretical claims tend to be general in nature. Theoretical claims pick out what is salient about the phenomenon that is being studied, and that generality comes at a cost, and the cost is that you cannot mirror real-life situations in picking out what is salient. So the role of a theorist is different, therefore, from the role of a judge who has to make an all things considered judgment in the real world. But that raises the possibility that the theorist might be cheating, and you put it a lot more kindly than that, but the question really was, am I cheating in claiming that the phenomenon is something other than what it really is? I don't think I'm cheating, at least not consciously so. So where I draw the practice from, and I try to answer the comparative puzzle by looking at 5 different jurisdictions, which were the US, UK, Canada, South Africa, and India, and seeing how these jurisdictions respond to certain key, to my mind, key concerns in discrimination law, questions that build up the architecture of discrimination law, and issues on which there was consensus within the jurisdiction were straightforward, but questions on which there was a lack of consensus. Obviously it involves evaluation and judgment, but I tried to see what the trend was, what the majority of jurisdictions were doing, and where the movement of the law appeared to be. And questions in which there were vast differences, I left them as unresolved, and therefore areas where theory can actually intervene and illuminate how the law ought to develop. And that approach obviously is going to be problematic for outlying jurisdictions in the sample. The United States happened to be one of the outlying jurisdictions in the sample. In a very curious and interesting way, it's the jurisdiction that almost invariably first comes up with the idea, which is then exported elsewhere, and then it's adapted, it takes root, it grows, etc. And then in the last 15, 20 years, we've seen this rollback in the US. But I think that rollback even in the US itself is contentious, and there's a strong dissenting opinion amongst judges and certainly in academics as to what the law should be. So all the doctrinal shifts, or at least some of the doctrinal shifts you articulated on indirect discrimination, on affirmative action, etc., I think they are by and large American phenomena and contested American phenomena. I think in other jurisdictions, and at least some of the other jurisdictions in my data set, those problems don't exist, and therefore as a theorist who is trying to figure out first what the phenomena should be, I had to make the choice of discounting what seemed to be the outlier in constructing my version of the practice. That said, your other point about the fact that the practice could have been different, and it's a series of historical accidents, the way that the slaughterhouse cases and even the civil rights cases in the 19th century were decided in the U.S. to the history of the Civil Rights Act, the fact that a British minister happened to be visiting the U.S. when the British statute was being drafted, and therefore borrowed the Griggs jurisprudence and transplanted it. You're absolutely right. These are indeed a series of historical accidents, and history could well have been very different, and the practice that might have emerged would have been very different. But I'm not describing that hypothetical world that might have been. What I'm trying to explain is the world that we are in, and also because this is not a historical account, but an attempt to give a theoretically coherent defense and explanation of the practice as it exists. I have to eschew a lot of these historical possibilities. But again, as I mentioned this in the book, so you're quite right that ground sensitivity is perhaps part of that accident. We may not have had it at all. In fact, the British common law on common callers, which looks like an anti-discrimination type provision, was not sensitive to grounds. It imposed a duty on all common carriers, innkeepers, blacksmiths to serve any customer who was willing to pay and act reasonably. So they were prohibited from refusing service on any ground whatsoever. The ground could have been race, sex, etc., but it could have been anything else. I don't like the look of you, or your physical appearance, etc. So, harassment. Many jurisdictions do have laws on harassment, including the UK, which are not sensitive to grounds, but they're not treated by the practice as aspects of discrimination law. And I think the reason that is the case is because the practice sees ground sensitivity and group membership as fundamental features of what we have come to call discrimination law. And I think the same goes for equality clauses, especially in constitutions. And it is undeniable that practice treats equality and discrimination as inseparable. But the way that practice understands equality is not how the philosophical literature understands equality. So the legal meaning of equality, in most constitutional clauses, 14th Amendment or Article 14 in the Indian Constitution, and I suspect the German Constitution as well, essentially require 2 or 3 different types of duties. One is of rational, sometimes proportionate, but usually rational state action. One is the anti-discrimination norm, and sometimes, like the Indian Constitution has added a non-arbitrariness duty under the Equality Clause. But that's not what most theorists mean by equality. So if the claim is that that equality in that legal practical sense is indistinguishable from discrimination law, or at least the discrimination law is a subset of that, I have no fight with it at all. I just think that if we want to really be pursuing equality as philosophers understand it, discrimination law will be lip service, will be paying lip service to the idea we ought to be doing a lot else and possibly things very differently to genuinely attempt to achieve equality. So those are my brief comments on your opening remarks.
Wonderful. Debbie, do you want to follow up?
Were you asking me?
Yeah.
Great. Could I ask a follow-up about the first question that is it group disadvantage that matters? And you said, Tarun, that, well, that's what discrimination law is focused on is group disadvantage rather than relative disadvantage itself. And then you made a kind of empirical claim, because I was really pressing, I agree with that descriptive point, but I was really pressing on the sort of why, if the grounds is securing our access to these basic goods so that we have freedom, I mean the ground, not, you know, grounds in that sense, what's special about group disadvantage? And you made kind of an empirical claim about the relationship between group disadvantage and the vulnerability to losing those things. That sounded plausible to me. I thought that you described it as not fully worked out, but I thought it sounded interesting and plausible. But what I wanted to ask is, what are the implications of that justification for certain kinds of grounds which might be contested today as possible additions to anti-discrimination law? And Julie mentioned appearance as one of the ones that's currently contested, and it would seem that your story about how group disadvantage, relative group disadvantage makes a person particularly vulnerable to losing those basic goods depends in part on the salience of the group as a group, for it to actually be different from just in relative disadvantage without the group aspect. And that's going to be less present with some groups than others, and so race or caste or certain religious groups might have been particularly salient in certain societies, but something like appearance I don't think is, it's not that a person's appearance isn't salient, but the salience of the group of people who are viewed as not attractive or something like that is not a salient group in that way. And so it might suggest, if this is the story you're telling for why relative group disadvantage is properly the focus of anti-discrimination law because of its role in securing freedom, it seems to suggest about this controversial case, appearance discrimination, that we ought not to add it as a grounds to anti-discrimination law. And I wondered about your thoughts about that.
Richard, are you happy for me to reply right away?
Could I actually jump in on this question? Because in some ways I think that Debbie's question, so why should we care about groups? If we're really concerned with freedom, then maybe we should just think about all the ways in which people are diminished in their pursuit of the essential goods that Tarun has identified. So that's one set of questions. I think on the other side, and in some ways I think my question about equality is related to this. In that if we're really concerned with freedom, maybe we wouldn't care so much about the groups or grounds that discrimination law tends to be obsessed with. On the other hand, if we're really concerned with equality, I think one thing Tarun says both in the book and in your comments in reaction was something like, well, if we were really concerned with equality, discrimination law, or we wouldn't just be doing discrimination law, we'd be doing a whole host of other things. And it seems like anti-discrimination law would be just a very marginal piece of equality. But I guess the question there is then, why can't we think of anti-discrimination law as a piece of that larger regulatory framework and sort of weaving in and out of that larger regulatory framework in the same way that I think if you were really taking freedom seriously and a philosophical account of freedom seriously, anti-discrimination law might be one of the tools that you use. But you might also think about other things like appearance and union membership, political opinions, and so forth that aren't really closely connected with group disadvantage because these are all things that could affect those freedoms. In which case, the conclusion we might be driving at is that anti-discrimination law itself maybe shouldn't be essentialized as its own legal category as we do the taxonomy, but just thought of as a set of practices that promote either freedom or equality or sometimes both, but that they change over time because of the connection to various normative agendas.
Thank you for those questions. So let me first clarify by saying why should we care about groups at all if what we're really concerned about is freedom? So I think this is the question that you asked, Julie. I think membership of substantially, pervasively, and abidingly disadvantaged groups is one special way in which our freedom is significantly compromised, just as being victims of certain types of criminal acts of violence is another way in which our freedom is compromised, and I think the same can be said for tort law, etc. So, and because of the particular nature in which this membership affects our freedom, it makes sense for the law to come up with specialized tools that address that precise problem. So there is a coherence about how group membership affects individual freedom. So you're quite right in saying that the ultimate concern of the narrative that I provide in the book is indeed with individual well-being. Group membership of a certain type happens to be the sort of thing that impedes individual well-being, and therefore the law has come up with the specialist tool set to break the nexus between group membership and with relative disadvantage. So that's why we are while trying to improve individual well-being, we are nonetheless concerned with groups in this particular area of law. You're quite right that freedom can be and is diminished in other ways, and the law does have to respond to those types of attacks on freedom. But this follows on to Debbie's question, which is, okay, even if we grant that, is it not the case that we should only care about groups that are salient in a social sense? I think this is where the priority of my two responses to your very first question becomes important, which is that that I don't need to deny that individual relative disadvantage might be of moral concern, but that doesn't explain discrimination law. And group disadvantage does, because of all its social implications. Now, it is true that when group identity becomes salient, its ability, and we are in empirical territory as analytical, theorists. So I realize this is treacherous waters, but we're doing armchair sociology here. So let me hazard a guess. It's right that identity politics does accelerate the process of acquiring the acquisition of these dominance, but I suspect that it may not necessarily be the case. So if one thinks of the disability rights movement, for example, the idea of the identity politics is still quite nascent in the disability rights movement, but that there we have an example of the absence of social salience to group membership, and yet serious and significant group disadvantage. I don't know what the answer to physical appearance is, the sociological answer to disadvantage faced by on the basis of physical appearances, but I think the answer will turn on the data about disadvantage rather than the data on group identity. And lastly, I want to add that social identity is also a dynamic and contingent fact. So a mere recognition of social disadvantage is often, or even the articulation of social disadvantage is often a catalyst for group identity forming around that issue. And again, disability or even the gay rights movement, I think are good examples of social movement coming about after noticing and articulating disadvantage. So I think that you're absolutely right that identity and disadvantage have a very close connection. But I would be hesitant to admit that identity is a necessary condition minus the disadvantage, or even with disadvantage.
Well, it's about 15 minutes into our conversation. I promised you about 35 or so minutes. Time flies when you're having fun, as they say. Perhaps a couple of more final thoughts before we close, because I'm attentive to your afternoon schedules. Julie, Debbie?
Julie, you want to go first, or should I?
So, sure, I'm happy to go first. So I guess I just wanted to pick up on, I think in some ways this is a very large set of questions that we're probably not going to answer in the 30 seconds that remain. But I do think it poses a very interesting question as to how to do theoretical work, not only in this area or in any area, because I think it's an exaggeration to call them a series of historical accidents. That is, there are doctrinal choices that are made that are politically and ideologically contested, that have different, by groups that have different normative commitments and foundations. And it seems like these historical accidents, as you call them, or these choices that are made doctrinally, don't always connect to each other because there are often compromises across different agendas. And it's something you touch on in your book by thinking also about the way in which the symmetry that we have in various areas of anti-discrimination law, the recognition of reverse discrimination, so-called reverse discrimination claims, are there in part because they support a politics that makes real discrimination claims possible. And I think once we have these, the history and the contingency of these practices, then we try to give a theoretical account, but the practices change because of the shifting normative agendas. And I think this then kind of messes up the normative account in the sense that then when we see the practices that seem like what you call outliers, the United States, but it's not just the United States. There are various aspects of European Court of Justice law on positive discrimination that I think is also, you might also describe as outlier-y. And if that's the case, it seems like you end up with a lot of practices that you could call historical accidents that don't fit the normative theory. And then the question is, if the practice changes significantly, not just in outlier jurisdictions, but in a significant number of them, do you have to revise your normative account, or would you rather have an account that starts with the normative and then tries to create a body of work that tries to reshape the practices that are coming along in light of that normative theory?
So I'm sitting here wrestling with, if I were teaching Tarun's book in a theory of discrimination law class, whether I would really describe it as based on freedom versus equality, as he says. And I'd be tempted to say, that's what he says, but it's not really true, because he describes the focus of anti-discrimination law as about relative group disadvantage. That is about, you know, what one person has as compared to what somebody else has, and you admit that it's comparative in that respect, or one group has relative to what another group has. So it's really focused on this comparative aspect, which is, to me, a kind of equality question. Now, you say at the deepest level we care about, I would say I would describe your theory as saying, well, at the deepest level we care about equality, or whether groups are treated equally, because that's important to freedom. But who's at the bottom, freedom or equality, or what values at the bottom, is a tricky question, because you could say, well, we care about equality because that's important to freedom, and we care about each person being free because people matter equally, and it's because we're all of equal moral worth or something like that, that each person is equally entitled to freedom, or something along those lines. So what's the value at the very bottom? I don't think anyone can say, and I think you can describe it as equally freedom or equality, but at the level of what's really guiding the practice, it's this comparative concern in your account with relative group disadvantage, which to me is an equality kind of concern. So I think I would say to my students that your book is still in the space of equality in its normative grounding. But I think it's an interesting question of how to describe an account as motivated by freedom or equality.
There's so much more to say, so many more questions to ask. For example, why Tarun pick those 5 countries? And why not focus on others? One might say that it's not a theory of discrimination law writ large, but rather a theory of discrimination law in Commonwealth countries. So another question might be, where is dignity in this discussion? We've heard about equality and freedom. What about dignity? So many more questions to ask, but unfortunately we have to stop there. Except for one more point, and it's not to make you blush, Tarun, but perhaps you will. when you and I first talked about this idea back in the fall semester, we put together a list of people that we'd like to have in this inaugural video interview series, virtual book reviews, author meets critics. And Debbie Hellman and Julie Suk were at the top of our list. And so that's just to thank you, Julie, and to thank you, Debbie, for your time. And
Thank you.
Tarun, of course, thank you for agreeing to be the guinea pig for this very first edition in what I'm sure will be a long series of author meets critics here at ICANN. So Debbie Hellman, University of Virginia, Julie Suk, Cardozo School of Law, visiting now at Columbia, and Tarun Khaitan at Oxford University. Thank you to all of you for this wonderful session.
And thank you. It's been a terrific pleasure.
Thank you all. Great.
Bye-bye.
Thank you.
Bye-bye.